till 1950, when the Tin Tabernacle moved, because at that point the Africans were moved to Jogoo, to what we have as St. Stephen's, and the Europeans moved to what we call All Saints Cathedral. But before that, in 1930, this building was put up as the first symbol of government authority around here. After we had the the judiciary building here in 1935, City Hall was built right next. So everyone else became a visitor after. Thereafter, in 1954, after the Tin Tabernacle had moved to Jogoo Road, is when Parliament building was put up. So you're our visitors. Between City Hall and the judiciary, we want to welcome you to Government Square. And then, of course, later on, Your Excellency, actually around 1950, in the 50s, is when Harambee House was actually put up over here. I'm very happy with the suggestion that all these arms of government can now come together to really concretize this Government Square. When we saw that ceremony, I think all presidents should be inaugurated here. And we hope in 2027, Your Excellency, we shall come for your inauguration at Government Square. And that I'll also walk across as the governor of Nairobi at that point. Your Excellency, in 2015, I was a member of Parliament and chairman of the Committee on Equalization of Opportunities and National Cohesion. We had gone on a trip to New Zealand to look at the history of the Maoris and the Europeans, and also Australia, the Aborigines and the Europeans, to see how they were able to come together. On my flight back, I sat next to a gentleman called Brian Johnson. Brian Johnson, because now you have to have small talk. We met in the lounge and said hi, then we realized we share a name, Johnson. And so just small talk, he told me he has a friend who has invested heavily in Kenya. This friend of his had been in Russia, he had been in Europe, he had put in investment, it didn't work out, and he had run into trouble in Kenya. And so when this gentleman learned that I was a member of Parliament, he told me, why don't you meet our friend and have a discussion to see how you can help him. Those days I was a bit powerful. I was the chairman of the ruling party, TNA, so I felt I could help him. This gentleman came to my office at KICC on the 26th floor. We had a cup of tea. He spoke about how Kenya is a great country, how we should market Kenya more. And then he finished and said, thank you, we will see you. And I told him, I thought you have a problem with your, what was called a little investment. He sat back down and told me, if you look at the amount of money we've invested in Kenya, if you look at the risk we've taken, if I needed to know somebody to sort out my problem, I would not invest in Kenya. This country has a strong judiciary. This country has the rule of law. My matter is in court. I am sure it will be adjudicated fairly. That gentleman, Your Excellency, is Steve Jennings, and his little investment is Tatu City. He did not want to know anyone, but he knew because you have a strong and firm judiciary, we have the rule of law. We have a court that can stop a presidential inauguration, and also a court that can quickly, swiftly, following the due course, swear in a deputy president. After other institutions have finished their work, Kenya is a destination for investment. He told me, Your Excellency, he told me that even if he was given free land in some of the neighboring countries because of diplomacy I shall not mention, even if he got free land, he would not move there. Because a change of regime would mean risk to his investment. I really want us to appreciate the judiciary of the Republic of Kenya. Because, Your Excellency, without them, this would not be a destination for investment. We congratulate you for the number of years that you've had. We have had ups and downs in this country, but everyone has always known that there will be objectivity in your findings. But your objectivity also must not mean popularity. It must mean just doing the right thing. I was thinking this morning when I came, what does it feel like to be a judge of the Supreme Court? I don't know, Emeritus Mutunga, how does it feel like? Chief Justice Maraga. It's almost a godlike. The finality of your decision. I would draw you to one of the poems by Khalil Gibran on punishment and crime. And he speaks to it. That must be exercised in a way that is judicious. Because ultimately, the ultimate judge is God. I really admire the judges of the Supreme Court that we have. You exemplify, that attribute that this country must be. And even us in other arms of government, we look up to you. On behalf of governors, I thank you because you have stood for devolution. You have supported devolution in this country. I remember as a senator marching to court. We frog marched our speaker. He didn't want to go. He's now a governor, Lusaka. He's governor again. We told him, you must go. Because at that point, we felt devolution was under threat. The deputy president was also there, marching to the court, Professor Kindiki. But we found solace. And many times, the judgments will not be popular to us or acceptable, but they must be respected. And so I am happy that we have judges who are immune to popularity. You don't have to make a decision whether that is popular. Leave popularity to President William Ruto, Professor Kindiki, PCS, and ourselves. We are the ones who want to be popular with the people. But for you, just do what is right, as sober as a judge, and our country will remain solid. Your Excellency, with those many remarks, I know we've had a discussion about our favorite topic, which is the land over here, the Nairobi County land, that will soon host the Supreme Court building. I had mentioned that I have never been a client of the Supreme Court. I don't intend to be in my individual capacity soon, unless I vie for presidency one day, you never know. But in my individual capacity, no. And so I would not want to be out of favor with the Supreme Court. The land over here, you have pronounced yourselves, and the Constitution Article 62 says all unalienated public land, as at the point of promulgation of the Constitution of Kenya, is vested with the NLC and with the county government. For us to do that proper allotment, following the procedures, to have a new Supreme Court building would be something that we'll all be proud of as a legacy of President William Ruto, myself, and the Chief Justice. So please count on our support. And also, Madam Chief Justice, you're the chair of our Nyumba Kumi over here, being the first resident. Please convene us once in a while. Convene your neighbors at City Hall, at Parliament, and at the Executive, even for a cup of tea. We'll be very happy to come. With those many remarks, Karibuni in Nairobi. I've been asked to welcome you to Nairobi, though I know all of you live in Nairobi. But I'm sure it feels nice to be welcomed by the governor of Nairobi every so often to your home. Asanteni sana, and may God bless you.
Thank you very much, Governor Sakaja. It is now my pleasure to call on the Supreme Court Judge of Kenya, Judge, Honorable Lady Justice Njoki Ndung'u, to make some remarks. Tumpigie makofi akija tafadhali. Welcome.
His Excellency William Samoei Ruto, President of the Republic of Kenya, the Deputy President, Honorable Professor Kithure Kindiki, the Honorable Chief Justice of the Republic of Kenya, Lady Justice Martha Koome, Honorable Chief Justices of various jurisdictions, Deputy Chief Justice Lady Justice Philomena Mwilu, Prime Cabinet Secretary, Musalia Mudavadi, the Governor of Nairobi County, brothers and sisters, judges, distinguished guests, ladies and gentlemen. It is my honor and privilege to welcome you all to the Supreme Court at 12 Jurisprudential Conference. In early March this year, the judges of the Supreme Court of Kenya, during our annual retreat, realized that the time has come for us to engage the Kenyan public, including ordinary Kenyans, civil society groups, members of the bench, members of the bar, and academia, as well as state actors who are affected by our decisions in their work and in their lives. We also determined that we would engage our colleagues in other apex courts, both in the African region and globally, to assess our progress as a court and to ensure we remain on course as guardians of the Constitution. It has always been the rule of thumb, however, globally, that judges speak only through their judgments. However, in the contemporary world, judges often find themselves under intense scrutiny and criticism without a chance to respond or engage, even to clarify, if need be, the reasoning of their decisions. Traditionally, judges have had no platform from which to speak apart from the courtroom, from where, in an adversarial system of justice, at least one party leaves unhappy. This conference is therefore conceived by the desire to demystify the court's role and processes and to correct misconceptions about its mandate by deepening public understanding of the court. While judges are not infallible, in a democratic space, the public need to be afforded structured engagement where, from time to time, they can learn about what judges do, where they sit, when and how they do their work, and most importantly, why they do it. This is the reason we are all here today, and this week, to share, to engage, to learn, and to reflect. Your Excellency, allow me briefly to reminisce on the history of our Constitution, and in particular, the evolution of the independence of the judiciary. Kenya's constitutional journey to date has been a fairly long and tedious process, from the Independence Constitution and to numerous amendments to it in 1964, and many from 1969 to 1991, and later in 1997. Many of those early amendments, particularly those before 1991, changed the character and tenor of the Constitution. Judiciary estimates were considered not independently, but we were considered a department, like the Office of the Attorney General. The security of tenure of judges was removed, drastically and adversely affecting judicial outcomes, with judges being appointed and dismissed at will by the President, and calls would come in at night from political actors directing what judges should do the next day. These were dark times indeed. Thankfully, this is no longer the case. By 1990, Kenyans were demanding for change, including opening up of democratic space, respect for human rights, accountable state institutions, and independence of judges. Comprehensive constitutional review, however, only began in 2000 with the appointment of the Commission, the Constitution of Kenya Review Commission, of which my brother Isaac Lenaola was a commissioner. That commission worked on a draft bill that was subject matter to the Constitutional Conference at Bomas of Kenya. Your Excellency, you will recall that in 2003, you were a member of the Parliamentary Select Committee on the Constitution. I believe that is where you and I first made acquaintance. And as members of Parliament, we were both delegates at the Bomas Conference, which adopted the CKRC draft bill in 2004. It is the CKRC draft that first made provision for Supreme Court. Similar provisions were contained in the document that went to referendum in 2005, but failed to meet the required threshold and was rejected. Kenya then went into the 2007 election without a popularly adopted constitutional framework, and as a result, in part, the election of 2007 precipitated a political crisis as never been seen before. As part of the resolution of the peace process that followed, the Committee of Experts on Constitutional Review, of which I was a member, was appointed to harmonize all the previous bills and drafts and to seek the views of Kenyans on contentious issues. And as a result, the Constitution of Kenya 2010 was adopted by Kenyans through referendum. This Supreme Court was birthed by that Constitution, born out of the people's vision for an apex court that would stand as the ultimate guardian of the Constitution and as an impartial arbiter for the nation's most difficult legal challenges. The Constitution gives the court original jurisdiction relating to any challenge of a presidential election result, an advisory opinion to be given to government, an appeal from a judge that has been removed from office, and any challenge on the validity of the declaration of a state of emergency. Of these four original jurisdictions, Your Excellency, the only one we have never invoked is the one relating to a state of emergency. In addition, The court is bestowed with appellate jurisdiction to hear any appeals on the interpretation and application of the Constitution, and also in the instance where an appeal is a matter of general public importance. The inaugural bench of 7 judges of the Supreme Court were appointed in June 2011. I was one of them. 2 others, Justice Mohammed Ibrahim, Justice Smoking Wanjala, are also still in office. We were later joined in order of appointment date by DCJ Rawal, CJ Maraga, DCJ Mwilu, Justice Lenaola, CJ Kome, and Justice Ouko. At this time, CJ Mutunga, DCJ Baraza, DCJ Rawal, Justice Philip Tunoy, Justice J.B. Ojwang have since retired. But going back to that inaugural bench, there were many challenges setting up a new court. When we first came here to report on duty, we found, as a totally new court, there were no offices for us to sit in, other than that of the Chief Justice, because even the Deputy Chief Justice was new. So we sat here and had a cup of tea in the CJ's office, and then we were asked to go home to wait until we were allocated temporary offices, a skeleton staff, and a courtroom. We had no rules of procedure, we had no practice directions, but there were already matters filed before us to get to work. And that we did. Over the last 12, now actually 13 years, the court has stood firm in its mandate, consistently asserting the principles of constitutional supremacy, sovereignty of the people of Kenya, and judicial independence. Challenges still, however, remain with regard to the principle of separation of powers, which guarantees judicial independence, particularly with regard to funding the judiciary as an equal arm of government, the attacks on judicial officers, and refusal to obey court orders. There is need, therefore, for checks and balances between the 3 arms of government without overreach or interference. Comity of the 3 arms of government is a cornerstone of our Constitution. Mutual respect is a necessary condition for the coexistence of the executive, legislature, and the judiciary, all who have one clear calling to serve the citizens of this great nation. Through landmark decisions, advisory opinions in moments of national impasse and precedents, we have strengthened our democratic foundation, and I believe the Supreme Court has continually sought to ensure that justice prevails for all Kenyans. This conference offers an invaluable opportunity to reflect deeply on the court's journey and to consider its impact and future direction of its jurisprudence. We will examine the paths paved by our decisions on critical issues, including presidential election disputes, constitutional questions, human rights, devolution, and so much more. The range of conference activities include public lectures, panel discussions, moot courts, interactive exhibitions, and stakeholder engagements, where we seek to enrich understanding and encourage dialogue about the future of the Supreme Court. As we embark on this conference, may our discussions be rich and enlightening. May they inspire fresh perspectives and reinforce our shared resolve in upholding the values enshrined in our Constitution. I thank you all and welcome you all once again to the Supreme Court at 12 conference. Allow me at this time to welcome to the platform the Honorable Musalia Mudavadi, Prime Cabinet Secretary, Ministry of Foreign and Diaspora Affairs, and the Acting Cabinet Secretary, Ministry of Interior, National Administration, His Excellency, Honorable Musalia Mudavadi. Welcome.
Your Excellency, the President of the Republic of Kenya, Honorable William Samoei Ruto, Your Excellency the Deputy President, Professor Kithure Kindiki, the Honorable Chief Justice Martha Koome, esteemed judges present, and our Chief Justices Emeritus, Professor Willy Mutunga and Justice Maraga, distinguished participants, guests, colleagues, ladies and gentlemen. When you have a privilege to speak to such an audience, you don't want to have anything that is off record. So I just thought I should make some very formal remarks. Since its establishment in 2010, the Supreme Court has been the final arbiter on issues of justice that go to the heart of our national conscience. The matters you discuss here today, from the traditions of apex courts to the nuanced balance of judicial independence and accountability, are central not only to your mandate, but to the very core of our democratic system. The Supreme Court is more than the apex court. It is the conscience of our Constitution. The Constitution of Kenya guarantees the independence of our three arms of government. Yet, while we are independent, we are not isolated. We are distinct, yet we are part of the same fabric that is Kenya. Our citizens do not separate us into the judiciary, executive, and legislature. They see only one government. And the expectation is for a government that works as a unified body to serve their interests, their needs, and their aspirations. Ladies and gentlemen, while the arms of government are independent, we serve the same citizens and the same republic, and as such, inevitably, all arms are interdependent. I urge each of us gathered here, within the judiciary, the executive, and the legislature, to champion this spirit of interdependence in our approach to public service. As members of the judiciary, I also urge you to continue taking a firm stance against corruption. The Supreme Court has the power to set precedents and to reinforce the standards of integrity and fairness that echo through all sectors of our government. I appeal to all of us in public service to be beacons of honesty and transparency that our citizens look up to and expect. The Supreme Court is the keeper of the promise of democracy and justice. Every decision made here impacts not just today's Kenya, but the Kenya of generations to come. Today, we are on a journey together. The Supreme Court does not exist in a vacuum. It exists in a society to serve the society. The African proverb, which you all know, reminds us that if you want to go fast, go alone. If you want to go far, go together. Let us be steadfast partners in building a just society, one where the rule of law protects every Kenyan and guarantees their rights and freedoms. As we continue in this partnership or interdependence, let us commit to strengthening our institutions, enhancing the capacity of our staff, and encouraging a renewed spirit of service to wananchi and for the national interest. This is our collective duty. Together, we can realize a more just, prosperous, and equitable Kenya. Thank you. I was told that I will now have the very rare opportunity to invite the Lady Chief Justice to the podium. Thank you.
Your Excellency, Dr. William Ruto, President and Commander-in-Chief of the Kenya Defense Forces, Your Excellency, Professor Kithure Kindiki, Deputy President of the Republic of Kenya, Chief Justices Emeritus, and our visiting Chief Justices, Your Excellency, Prime Cabinet Secretary, Honorable Musalia Mudavadi. Allow me also to acknowledge the protocol that has been set and abide by it, and recognize my brother and sister judges from the Supreme Court, from all the courts, and all the visiting justices, and our esteemed members of the Judicial Service Commission, distinguished delegates, ladies and gentlemen, good morning. On behalf of the Supreme Court of Kenya, I am most delighted to welcome you all to this conference as we commemorate 12 years since the establishment of the Supreme Court of Kenya. Allow me to particularly single out for special mention and recognition my brother and sister Chief Justices and judges from other jurisdictions who have traveled from across the continent and the world to join us for this conference. Let us appreciate our esteemed guests. The theme of the conference, reflecting and introspecting on the Supreme Court of Kenya's jurisprudence, 12 years of defending the Constitution, captures the dual purpose of our conference, which is to celebrate the milestones we have achieved while critically examining the journey we continue to chart as Kenya's apex court and the ongoing commitment to uphold justice, to uphold constitutionalism, and to uphold the rule of law. At the heart of this conference is the idea that institutions matter. Institutions are the anchors of our democratic aspirations. The establishment of the Supreme Court as the ultimate interpreter and guardian of the Constitution embodies the expectation that the Supreme Court provides stability, certainty, and predictability in resolving the inevitable conflicts that arise within our society. Therefore, we are affirming the idea that our future lies in building strong and robust institutions that will serve as the catalysts for the national progress and development. Your Excellency, ladies and gentlemen, over the past 12 years, the Supreme Court has played a transformative role in shaping both Kenya's jurisprudence and shaping our country's socio-political development. These court's landmark judgments have influenced the daily lives of Kenyans while reinforcing the core principles of our democracy. Through hearing and determining 4 presidential election petitions over the last 3 election cycles, the court has set critical benchmarks for conducting free, fair, and transparent elections. Likewise, through the landmark advisory opinions on devolution and the relationship between the bicameral houses of parliament, the Supreme Court has developed guiding frameworks that clarify interactions between the National Assembly and the Senate, reinforcing devolution as a cornerstone of our transformative constitution. Furthermore, in defining the parameters for constitutional amendments in the BBI case and establishing principles of public participation in the BAT and recently in the Finance Act cases, the court's jurisprudence has strengthened the democratic foundations of governance and harmonizing the judiciary's benchmark on the areas of public participation that still requires parliamentary action. The court's decisions have also directly addressed issues of land rights, human rights, social and economic justice, and family law. In the same vein, the courts have addressed housing rights jurisprudence in the Me Too Bell cases, which reflects the court's commitment to socioeconomic rights. The courts has set jurisprudence guiding the families on how to uphold the family as the cornerstone of our society. In this and countless other judgments, the Supreme Court has affirmed its role as a transformative agent in the society. Despite the inevitable pitfalls of perception or capture that come as a result of the court's invitation to address political questions, the court's jurisprudence has purposefully harnessed the Constitution as a powerful tool to promote the well-being of individuals and driving societal transformation for the common good. Notably, the decisions of the Supreme Court of Kenya have garnered significant respect and citation across the region and beyond. This recognition in the global legal community underscores the court's maturity into a respected institution whose well-reasoned judgments contribute to the evolving discourse on the law and justice worldwide. Your Excellency, ladies and gentlemen, the journey of the Supreme Court has not been without challenges, as explained by the Honorable Lady Justice Njoki Ndung'u. But as we strive to deepen jurisprudence and protect the Constitution, the court is often called to balance divergent interests and expectations while upholding the law. It is important to appreciate that the Supreme Court's jurisdiction, to a large extent, has a political dimension, given that this court handles matters touching on governance, the exercise of political power, and presidential election petitions. The court inevitably gets drawn into disputes relating to the exercise of a political mandate. And this has led to the court being subjected to political verification and being a target of political rhetoric over the past 3 electoral cycles. I want to take this opportunity to assure Kenyans that in the discharge of our mandate, we do not get drawn into making political decisions. We look for legal solutions for political disputes. The judges are politically neutral and are concerned with only determining the legal and evidential issues before the court, irrespective of their political ramifications. Going back to the history that informed the jurisdiction vested in the Supreme Court, particularly the exclusive jurisdiction to hear and determine presidential election disputes, there is need to sustain public confidence and trust in the Supreme Court. Without a court to turn to for resolving political disputes, our country will risk being left without an institution to arbitrate and resolve these disputes that involve politics, and governance. And these disputes have the potential to tear down the country. I therefore urge political prayers and other Kenyans to reinforce and build public confidence in the work of the judiciary and the Supreme Court. Recently, I have been reflecting on the role of the three arms of government and the need for each arm to shield the other from taking on mandates that are separated by the Constitution, so that we can truly live by the spirit and principle of separation of power. When courts are invited to deal with political questions presented in a legal nature, there is an inevitable risk of being drawn into perceptions that plague political play. Although this is an Anglo-Saxon problem, as we see in jurisdictions that require some political jurisdiction from their apex courts, we must, and indeed we do, approach every issue with legal lens. It is important that political institutions exhaust all political solutions and only turn to courts as a matter of last resort. And when I look back at what happened to us in 2007, when we were visited by post-election violence, when I look at what happened in 2017, and also 2022, the maandamano, and the creation of the nusu mukate or half-loaf bread government, the handshake government, and now the broad-based government, I always wondered, had we sat down under our provisions of Article 159 to reason